Hi, I'm Gary DeWitt. I own DeWitt Law Firm where I do estate planning and probate and do it well. Today I'll tell you if you need to update your plan after a divorce. I had a previous planning client come in after her divorce and ask if her plan needed updating. She had a will and powers of attorney. My first answer was it depends on if your plan has language about divorce built into it. If you have questions about what we are talking about today, if you have estate planning questions, if you have probate questions, if you have questions in general, or just want to talk, go to planwithgary.com, or you can call or text 479-717-6300. And that is the answer. If your plan has contingencies for divorce built in, then you probably don't need to update it. If it doesn't, then most of it will need to be updated. In general, powers of attorney are not affected by divorce unless they have language built in. In general, trusts aren't affected by a divorce unless they have language built in. But in Arkansas, gifts left to an ex in a will are nullified by law. But if they are named as executor, then unless the will has divorce language built in, they will probably be the executor. Beneficiary designations, beneficiary deeds, pay on death, and transfer on death are not changed by a divorce. All too often, an ex gets the payout from a life insurance policy because somebody forgot to change the beneficiary. In general, it is best to have your documents reviewed after a divorce to make sure your ex is completely out of the picture. By the way, the client that came in had language in both the will and powers of attorney that automatically removed the ex. I want to remind you, if you have questions about what we are talking about today, if you have estate planning questions, if you have probate questions, if you have questions in general, or just want to talk, go to planwithgary.com. Or you can call or text 479-717-6300. Thanks for watching.